Okay, let me see how I can be able to conclude in that. So what is the solution? What is the ultimate solution in regard to this? Number one, the challenges that we are facing in backlog of cases and challenges related to access to justice will be resolved through mediation, and the search for justice at the community level can only be cured through creation of mediation processes at the at the community level. Thank you.
Thank you very much. We've ended on mediation. We started keeping time well, but I seem to have slacked. And it is because they were young men and I didn't want them to say I am oppressing the boy child. So next time I'm not going to be as nice to the boy child. We will have a short break now. And for those of you who are leaving today, please check out. It is now 10:38. If we can come back by 11. Okay, so tea is not ready, so we go on. You see, I'm not the one who is the slave driver. So let's go on. Please, let's keep the 7 minutes because I notice the energy goes down. When you have a whole paper, but you must speak to your paper in 7 minutes. Can we agree on that? Yes. Boy child, girl child, elders, everybody. Okay, so the next presentation is by Jemima Collins Aluda. And because I have seen your body language, yes. I'm going to be brutal. Okay.
I don't like
okay.
I can stick to it, but I'd requested to project so that it's very fast. So 1 minute, please. The people from the back come and assist me.
So those who are leaving today, remember to check out, because if you don't check out in good time, then there is a charge, and we don't want to leave bills that are unnecessary. We want to manage our resources all around in an efficient manner.
Okay, so my name is Jemima Aluda. I'm sorry, from the program you are sent to is indicated that I'm from the ODPP. I left ODPP in December last year. So now I'm a practicing lawyer and a consultant. And I'm going to present to you a paper on the role of alternative justice system as complementary pathways for enhancing access to, intersection between AJS and the formal justice system, that is looking at the perspective of the criminal justice actors and the role of the prosecutors. Okay, I'll request that you just give me 1 minute for the projector to come up, because it will be faster when you just look at the slides to shorten it to the 7 minutes requirement. Okay, so there we are. I require your attention within the next 7 minutes. And so our customary justice system is mostly preferred by the poor, especially in the rural areas. And numerous council of elders and informal groups have positioned themselves as those who promote justice. But we have various NGOs that have been able to strengthen customary justice with an infusion of human rights principles, as we are given the example of Kelly, FIDA, and the like. There was a justice needs survey that was done in 2017, and the results were that 2 out of 3 Kenyans have encountered disputes, and out of these, 81% of them resolved to dispute resolution mechanisms. However, only 21 resolved to court, meaning we have 79 people who do it outside the court system. If you look at the river of justice, it's in the AJS policy. I happen to be one of the task force members of the AJS policy. There are various forms of resolving disputes, traditional, religion, peace committees, courts, mediation, arbitration, family, community, and all these, as I've indicated, only 21% resolved to go to court. On 2nd of November, President Obama made a speech on criminal justice reforms and said, right now there are 2.2 million Americans behind bars. We incarcerate people at a rate that is unequaled around the world. Around 70 million Americans, we have some sort of criminal record. I think this reflects well in the Kenyan criminal justice system. That record disqualifies them from participating fully in the society with the requirements, even in Kenya, of issuance of records from the police. Then, so we must reform our criminal justice system to be fairer, to be smarter, and to be more effective. Ladies and gentlemen, my paper looks at the difference between restorative and retributive justice, even as we look at alternative justice system. And so the main approach of alternatives to prosecution is to enhance restorative justice rather than retributive justice, whereby we are looking at the perpetrator, but in restorative justice, we are looking at the role of this person in the community as a whole. And so the importance, it helps the youth, the community, it helps the victims, it helps in prosecution of civil protection issues. It's an alternative to incarceration. And so there are various guiding principles when a prosecutor needs to look at the file and decide, am I going to the court system, or do I approach the alternatives to prosecution? There are various alternatives: plea bargaining, diversion, warning, caution, compensation, traditional justice mechanisms, and deferred prosecution agreements. I know that we know about diversion, which we divert the offender from the criminal justice system outside the court system. Informed warnings, for instance, in traffic cases whereby you are arrested and then you are cautioned, or you are informed not to repeat that offense. Conditional caution, you are given a condition for you to be able to fulfill, for instance, to go through rehabilitation, then you can be able to your matter can be resolved outside the court system. So the conditions can include rehabilitation, reparation, whereby you repair the damage, and then punitive, whereby you are penalized for the offense that you've done, for instance, payment of a financial value or payment of fines, and this one mainly in offenses of strict liability. Ladies and gentlemen, I know we've talked so much about traditional justice mechanism, but also in criminal cases, we employ traditional justice mechanisms, especially like in Somali community, where they resolve cases by payment of camel undertakings to take care of the bereaved family. We have the Gashasha courts in Rwanda. So they're usually used where the Council of Elders resolve disputes, and these include criminal aspects. Plea bargaining and agreements, we know that the DPP launched the plea bargaining agreements and explanatory notes last year in terms of how to be able to handle plea bargaining, but also a way that you can be able to use outside the court system. Then compensation, where you are asked to compensate for the injury or for the loss to a victim, and the views of the victim must be taken care of when you look at compensation. Ladies and gentlemen, there's this new component called deferred prosecution agreement or out-of-court settlement. This one is mainly used when you're dealing with corporates. And the DPP has deployed these when they're using the banks in issues of financial reporting and economic crimes. So you enter into an agreement with the institution so that instead of now taking perhaps the management of the bank to court on issues of financial reporting and economic crimes, you enter into an agreement and then the bank will be able to compensate. This is how last year, during the COVID pandemic, you had that the DPP had acquired 2 billion in economic crimes from certain banks. I'll not be able to mention the banks here for confidentiality purposes. So this, the University of Nairobi recovered a land that was worth billions in Hurlingham through the deferred prosecution agreement. What is the role of the prosecutor, ladies and gentlemen? Prosecutor serves as a gatekeeper to the criminal justice system. So you decide the way to go. So as a prosecutor, we encourage that you employ alternatives to prosecution as much as possible instead of using the formal court system. What is the role of the DPP? The role of the DPP, as was mentioned in the case of Abdullahi Nur Muhammad, must be looked at when you're entering into prosecution alternatives to prosecution in criminal matters. Some of the challenges that you have are statutory limitations, for instance, in Sexual Offences Act and International Crimes Act, unwillingness to participate in alternatives to prosecution. It's prone to abuse because of lack of transparency, integrity, and corruption, and then there are difficult conditions applied in applying for alternatives. Ladies and gentlemen, what are the recommendations? To continue to train public prosecutors and investigators on applicability of AJS, review the criminal framework to accommodate, promote AJS, inform the public of the AJS framework in criminal matters, and lastly, the court should refer criminal cases in their dockets to the AJS framework as we do the court annex mediation. Thank you so much for listening to me, and I'm available for any questions and clarifications on issues of AJS and criminal justice system. Thank you.
In time, I'd like to notify you of a very significant thing that has happened as the presentation was happening. Mr. Wambua Kituku has just been conferred the Doctor of Doctor of Philosophy in Law at the University of Nairobi. Yeah, so he walked in here, Mr. He leaves Doctor. And that's a good thing. So shall we have the next presenter, Jemima Kelly?
Good morning, everyone. Allow me to start by acknowledging my two professors in the house, Professor Kamore Bote and Professor Lumumba, for my undergrad studies in law and LLM level. So much has been said about traditional justice systems, and coming at the tail end, some of the issues I wish to address have already been addressed. So for me, I wish to make a case for traditional justice systems in promoting access to justice. Listening to previous presenters, I got the sense that there is a misunderstanding of the place of traditional justice mechanisms in the society today, especially vis-a-vis the esteemed status of the modern law. Our Constitution itself, Article 1593B, uses strong words to qualify transitional justice mechanisms or transitional dispute resolution mechanisms by qualifying that they should not be repugnant to justice and morality. On joining the University of Nairobi, in our first term, we were introduced to jurisprudence, and customary law was treated as the last in the hierarchy of laws. And these words were used strongly to undermine customary law. And this continues. And I have listened to some of the speakers, and I see this kind of training has been internalized in us, such that we believe that customary law is actually repugnant to justice. And I want to try and demystify traditional justice mechanisms in order to help us understand. Human society has had justice systems for as long as it has existed. In Kenya, the different communities that existed before colonial occupation and rule had their own systems and mechanisms of justice. These systems were referred to customary or traditional systems, although they have undeniably been altered through the encounter with the colonial and post-colonial legal systems. The essence of justice is to ensure proper and fair administration of laws. That is the essence of justice. And that's the question we should ask ourselves is, do the traditional dispute resolution mechanisms ensure fair and proper administration of laws. And these laws include, of course, our own customary laws, which do exist even in the modern society. Now, if I may just, as a way of introduction, a sample of transitional justice mechanisms in various African countries, and I did look into the Gashasha of Rwanda, the Karamojong of Uganda, the Mende tribe of Sierra Leone, and of course our own communities. I looked at the Kamba, the Meru, the Rendile, among others. And they have shared traits of reconciliation, restoration, and retribution. Reconciliation is about reconstructing relationships in a way that allows everyone to move forward together. Retributive justice is based on the principle that people have committed human rights violation or ordered others to do so and should be punished in courts of law, or at minimum must publicly confess and ask for forgiveness. And those who are familiar with the Gashasha proceedings, especially post the genocide, this was an emphasis in that system. People also uphold a punishment as necessary so that perpetrators are accountable for their actions, and also to deter future crimes and counter a culture of impunity. And then we have lastly restorative justice, which is a process through which all those affected by an offense, whether victims, perpetrators, and communities, collectively deal with the consequences. It is a systematic means of addressing wrongdoings that emphasizes the healing of wounds and rebuilding of relationships. Truth-telling and meeting of victims and perpetrators are important in the process, as are expressing remorse and making restitution to the victim or his family. So for me, that gives the case of what transitional justice mechanisms are all about and what they look like. We do have legal framework recognizing transitional justice systems, and due to time, I will just highlight some of them. We have the United Nations General Assembly Declaration on the Rights of the Indigenous Peoples, and this was a 2007 declaration. Among others, it states in Article 40, Indigenous people have the right to assess and prompt decision through just and fair procedures for the resolution of conflicts and disputes in the states, as well as to effective remedies. And then, of course, these, we are guided by the UDHR and the CCPR and other legal principles which our Constitution has adopted under Article 2. So even as we apply these customary mechanisms, they should be respecting the general principles of law. Our own Constitution has recognized under 159 transitional justice mechanisms. The qualifications, as I indicated, one of them is that they should not contravene the Bill of Rights, and they should not be repugnant to justice and morality or be inconsistent with the Constitution and the law. We have other laws, consequently. We have the Community Land Act recognizing transitional justice mechanisms, and this is important especially for community-owned lands. And the National Land Commission actually is encouraged to apply transitional justice mechanisms. Now, even on our own Marriage Act, those marriages under customary law, they are first to be tried to be resolved under the transitional justice mechanisms. And of course, that would be like application of mediation. And so we see that post the 2010 Constitution, transitional justice mechanisms are taking a better place. I see my time is running, and I respect my professor, so I will try and see how to conclude on this. Since we have really been taken through the transitional justice systems, all I can say is that our reality as a country, the fact of the matter is only 10% of our disputes are going to the courts. The question we should ask ourselves, where are these other disputes being resolved? And the reality is our larger population lives in the rural areas, and they are actually applying transitional justice mechanisms. You can see under the northern community, they have the masla, where they are resolving murder cases, among others. And the court in one of the courts in Nairobi, High Court Nairobi, criminal number 86 of 2011, actually upheld that conversation through masla. And this is what the court said, if I may just read. I know my time is running. And the judge says that in the unique circumstances of their present application, I am satisfied that ends of justice will be met by allowing, rather than disallowing, the application to withdraw the case. And this application was made by the DPP. And of course, I'm trying to respond to an earlier presentation, I think it was by Shem, which said that murder cases should not be solved through transitional justice systems. For me, all what matters is that the rights, there is a semblance of fair trial, and the rights of the victims are respected, the victim family, and this is done through the conversation. There is the fact of truth-telling, apologies in public. So these components then make them attractive to the society, the Kamba community as the Mahambo, which is equivalent of Masla, compensation for murder. And for these cases, you will not find the witnesses coming to court. And that's how the cases are not able to proceed in most cases. They will not even apply to withdraw. The cases will die a natural death. So, and the communities are satisfied with that form of justice system. So my question, and I would pose a challenge to all of us, what makes the modern law so superior to our own tradition, such that we say even murder cannot be dispensed, the justice system cannot work in killing. And for them, they don't call it murder, they call it killing. The modern system has manslaughter and murder, meaning it differentiates different types of killing. Under the traditions of especially the Mambo and the Masla, the Somali community and the Kamba community, there is no difference. Killing is killing, and the compensation must happen. In the modern system, one can get away with the defenses, of all manner of defenses. They can get away with the killing, yet you cannot get away with the killing under the traditional justice mechanisms. So in conclusion, and especially on the issue of the elders, I would just read out some of the recommendations I have for the elders. And these recommendations have been upheld, I think, in one of the guidelines to Council of Elders by FIDA Kenya, which were done with approval of the UN Women and the UNDP. 1 minute, please. Let me just finish on this. And one of them is that we should emphasize on 4 themes when it comes to Council of Elders. 1, adherence to the Constitution, and this would be ensuring that the Council of Elders do not contravene the Bill of Rights, and they should also put in mechanisms, especially to address the concerns that they do not recognize women. Find a way of addressing that challenge. Accountability and transparency, they should be accountable. The Council of Elders should be accountable, and this can be done by recording their processes and their resolutions. They should establish and maintain networks. They can have places where they discuss among the various councils in Kenya. They can discuss their challenges and ways to overcome those challenges, and documentation. There is need for documentation of decisions made. In the event one wants to appeal to the court, then they should be able to take that decision on appeal. Thank you so much, Professor, for giving me an extra minute. Thank you.
Thank you very much. I think, again, we go back to the issue of decolonizing our minds. and limitations that we place on traditional justice systems. And I think Jemima has raised indirectly an issue. If only a paltry of the cases or disputes that arise go to courts, and we are putting, when we talk about access to justice and investment in that, we are putting most money in courts, then aren't we ignoring the justice needs of the bigger part of Kenya's citizenry? And we need to begin to think about, as we talk about legal aid in schools, in law schools, maybe that is where it starts. That's where the buyer starts. I think it's Professor Lumumba who talked about the course on customary law having no takers. I think now we have somebody who teaches customary law, but I have very many professors around Africa who say, why I will not teach customary law? And it's not because they view it with a jaded lens. It is also our mind as lawyers is so colonized by concepts about what is law that customary is really not law. We may give it, we'll listen to Commissioner, we'll listen to Jemima tell us about Maslach, we'll listen to all these discussions, but in our mind, we know that is baby law. The law is the other one. So if Dr. Aura tells me that tea is ready, we'll go and have tea and come back at, it's now 11:05. If we can come back at 11:30 so that we have the other presentations and then have a little time for people to reflect. You know, if you talk too much as a presenter, you deny others the right to express themselves. So let's go for tea. And those who are leaving today, please remember to check out. Okay.